Hi, everyone. Welcome to today's episode. Today, we're discussing ways that you can keep your VA benefits safe. You want to avoid the common mistakes on your VA claims that we're going to speak about today. I'm Maura Black. I'm a managing attorney here at Chisholm and Kilpatrick. This is Claire Babcock, an accredited claims agent at CCK. And Claire, do you want to start us off with the first mistake that we want to warn people about?
Yes. So the first mistake or error that claimants can make in the VA process is failing to file a claim or appeal in time. So, why is it so important to file claims and appeals timely?
Well, if you're thinking about filing a claim, you want to file that claim as soon as possible. Sometimes we encounter veterans who are thinking about filing a claim, but they're really thinking about what kind of evidence they want to present with that claim. That process can take time. So, what we advise is just file the claim as soon as possible because the filing of the claim will start the potential effective date that you could receive if VA later grants your claim. So if you file a claim on a certain date, usually, as long as the merit is there, and that's a whole different story, but usually VA will grant benefits as of the date of your claim. So since the benefits will go back to that date, you really want to be mindful and file your claim as soon as possible. You can supplement your claim with information later, but if you wait too long, it can mean losing months or even years of compensation.
Yeah, that's a great point. And another thing that I think we talk more about is the importance of filing an appeal timely. So, maybe could you talk more about the importance of that?
Yes. So separately, appeals have to be filed in a timely fashion because there are strict deadlines for appealing an underlying rating decision or a decision from the VA. So, generally speaking, if you receive a decision from the VA, you have 1 year to appeal it. There are some exceptions to this rule. Sometimes, if you receive a proposal, there are response periods that are shorter than the 1 year, but a response is not technically required. But for the most part, if you get a decision, there's a 1 year appeal period. Usually, your decision will contain a standard letter or two that explains your appellate rights. So, you want to be looking through your decision and seeing what VA is advising you about your rights to appeal. Those rights to appeal will typically include the time that you have to file an appeal. But you have to file within the year period in these situations we're talking about generally, because if you don't, VA will not be obligated to accept your appeal. That would mean if you don't get a chance to appeal, if you don't file it timely within that year in response to a VA decision, you would need to start the process over. So you'd need to refile your claim. The other consequence too is that you would lose the earlier effective date. So if you file a claim, get a decision that denies benefits, and don't appeal that decision, you haven't been able to maintain continuous pursuit of the first claim that you filed. So you're cutting off the potential effective date from when you filed that first claim, which again, just like in the claim scenario, can result in a loss of benefits for a period of months or even years.
Right. So, a disabled veteran has a lot on their plate. What would happen if, they don't feel that they can file a claim or an appeal in time?
This is a good point. You definitely don't want to be in a situation where you feel like you are um, running up against the clock, especially with an appeal. So, things that you can do to help yourself: find a reliable veteran service officer to help you. Remember that you can submit an intent to file for a claim. In some instances, you can also file an intent to file for a supplemental claim appeal. This will be a placeholder for the effective date that you want while you have a little bit more time to get your claim and any evidence in. For appeals, because there is no wiggle room with those deadlines, you want to consider a VA accredited law firm to help you. They can take care of some of the heavy lifting for you. They can keep an eye on deadlines and the dates that are relevant in your case. You can take advantage of their knowledge of the process. Um, the flip side of needing to quickly file something on the veteran side of things to meet deadlines is that on the other side, sometimes VA is taking a really long time to decide your appeal. Um, VA attorneys and accredited agents have knowledge about how to reduce those delays that you might experience and to deal with other challenges that can come up in the VA context, even in the US Court of Appeals for Veterans Claims, if that's necessary.
Right. Another common mistake or error that comes up is using the wrong form or filing a form incorrectly. Um, how can veterans avoid filing an incorrect form, filling out their forms incorrectly?
So VA has a very specific forms regime. Sometimes we say that. They're really strict about what kind of forms you need to file to get a claim in or to get an appeal in. So you want to make sure that you research the needs for each claim or appeal situation you're dealing with. Do not rely on word of mouth. It can be tempting to talk to friends or peers about what they did. But since there are different appeal lanes that you can take, and there's different types of forms that are required for new claims or reopened claims, you really want to do some research. You also should always check, in our experience, we check the VA website. You can go to VA's website to a section that talks about forms. You can find their most up to date forms. Since VA forms change a lot, you want to make sure you're using the latest version of the PDF of the form. We've run into instances where we file something timely, or a veteran will file something timely, but if it's on the old version of the form, we can run into some issues with VA accepting it. So that's something you want to be looking out for. Always double check your forms and appeals for accuracy. This can be really helpful to get someone that you trust to be a second set of eyes on your submissions. Even little things, little mistakes that you think might not be significant could be reason for VA to bounce your form or reject your appeal. And that's a situation you don't want to have to deal with. That can trigger a whole slew of letters and other deadlines that you have to meet to be able to get the prior filing established. So once you send something out the door, you should really be sure that it's in good shape and reach out to others for help with that process if you feel like you need it. And I mentioned that the forms that you might use are available on VA's website. Other forms are there as well, like disability benefits questionnaires. Um, and just again, we can't emphasize this enough. If you send an incomplete or incorrect form, VA is going to notify you and provide you the opportunity to cure the issue. But those can be really tricky situations to deal with. So definitely check for accuracy, and after you submit something, be on the lookout for any notices or letters that VA sends to you. They may identify an issue in a form or appeal that's not actually an issue, but you still want to have a chance to have the final word on it and make any corrections that are needed.
Yeah, I know that, the last 5 years we've had the appeals modernization system in place. And I think I've found that the different types of forms, the different
Mhm.
types of lanes, it's only getting more complicated for veterans. And so it's really helpful to get help from an experienced representative. Um, Related to what you mentioned about disability benefits questionnaires,
Mhm.
another common mistake or missing element that we might see is the lack of a medical nexus. And that could be a
Mhm.
setback for a service connection claim. So I wonder if you could talk more about how the lack of a nexus impacts those claims and just what a nexus is.
For sure. So, if you're filing a claim for service connection, if you are trying to demonstrate to the VA that you have a disability that began in service, and this would be for instances where there is no presumption. So, if you're filing for something based on a presumptive exposure, um, or even under the PACT Act, the nexus element might be removed in some of those situations. But if you're filing an increased rating claim, or again, another a service connection claim, you want to be mindful of the burden of proof that you have and the type of evidence that you need to submit to win that claim. For service connection, there are 3 elements that you need to demonstrate. You need to have an existing condition or a disability. You need to have an in-service event of some kind. And then you need to have a nexus. And to Claire's question, a nexus is the link between your disability and the in-service event, onset, or exposure of some kind. A nexus is a critical part of service connection, and we see folks sometimes run into an instance where they are leaving service, they're a new veteran, and they want to file for things that they believe, disabilities that they believe began during their service. It's not a foregone conclusion that just because maybe you have one note about something in your service records or you didn't have any pre existing diagnosis, that VA is just going to grant that as service related. VA is going to be looking for that nexus element. So, something that specifically speaks to the link between your disability and your time in service. So, to prove this element, you can think about getting a nexus letter. A nexus letter is an opinion from a medical professional or a clinician that will say this veteran's disability, whatever it is, began in service because here's the link. This is why this condition is related to their service or the activities that they completed in service. And in cases where the issue is for direct service connection, so again, not conditions that are presumptive, you really need to be thinking about this piece of evidence. Again, I'll go back to the earlier discussion that we had. You can still file a claim without this because you want to get your claim in as soon as possible. But just be aware that this is going to be something that VA will look for, either from you or perhaps from a VA examiner down the line, because they're really going to be looking for this nexus element to be able to grant service connection.
Yeah, and if you do seek a Nexus opinion from your treatment provider, it's important to know that the standard that VA looks at is at least as likely as not. So it doesn't have to be 100%. It just has to be the evidence for and against is approximately even.
Mhm,
That can fulfill the Nexus element.
mhm,
So, another switching gears a little, but another common mistake that we might see in VA claims is submitting either insufficient evidence or submitting evidence that is irrelevant to the claim. So, I think that kind of raises the question of how much is enough? What should
mhm.
veterans be submitting to satisfy their claim, but also not provide too much or information that isn't helpful?
This is a really good question and something that we struggle with and that we know our clients struggle with. It can be really tempting to think that more evidence for your claim is better. Here's all the information that I have. Here's a complete history of my medical conditions. This is everything that happened to me in service. These are my personnel records. Of course, all those pieces of evidence are very helpful, but thinking about how to synthesize and focus what you have to meet the elements of the claim that you're trying to prove is really kind of the art of demonstrating your entitlement to benefits at the VA. So, what we recommend is if you are filing a claim for a benefit, you want to first get familiar with what are the elements that you need to prove to win that claim. I just talked about service connection. The three elements are you have to have a disability, you have to have an in service event, and then you have to have a nexus between the two. So when you're making a submission, think about framing your arguments or your evidentiary submissions around those three elements. It is okay to avoid submitting things that do not speak to those three elements. Loading the VA up with paperwork with how delayed and backlogged they can be is not always a good strategy. So if your evidence is relevant to your time in service, it doesn't mean necessarily that it's relevant to your specific service connection claim for, let's say, your back disability or your knee disability or something specific. Similarly, if you're filing for an increased rating, you want to think about what evidence strategically shows that your disability has worsened and warrants a rating higher than the one that you already have. In increased rating claims, it's really important to look at the diagnostic code that's applied to your condition and the different criteria that are available or that apply to a higher rating. So, along the same lines, think about what the law says about how to prove entitlement to a higher rating and build your evidence and your submission to the VA around that. For TDIU, you want to be submitting evidence of unemployability, and the evidence of unemployability has to demonstrate that that unemployability is due to your service connected disability limitations. I would say TDIU is the area where we see the temptation to submit a lot of superfluous material. It's not that it's not accurate, relevant to your experience in service, relevant to your post service disabilities. You need to be focused though. If you're trying to show that you should get TDIU because of service related limitations that prove your inability to work, your submission needs to be targeted to what do you have that's service connected and what are the effects of those conditions that prevent you from working in a substantially gainful occupation. There's a lot of resources that are available for researching what the parameters of a claim are that you need to satisfy. There's a number of tools and resources that we have at cck-law.com. You can talk with a VSO to list common types of evidence that would be helpful for a particular claim. That can be a helpful process too. But again, I would definitely start with what are the elements of the thing that I'm trying to get, and how do I build a submission around what those elements are?
Yeah, that's a great point. And VA a lot of the time, I think they make favorable findings that you can hold on to. So
Mhm.
if VA has already found that that back or knee disability is service connected, and you're trying to pursue an increased rating or a TDIU, you don't need to go back into the service connection element that is already satisfied, that is settled, so you can try to prove the other elements that you need. So
Mhm.
I think that saves time and
Mhm.
helps hopefully make the process more efficient. So finally, let's discuss the mistake of not seeking professional help when you need it. How can this affect the outcome of a claim?
Great question, and it's kind of one that we may have already answered earlier. But going it alone in the VA process can be very, very challenging. Take it from us. We help people all the time that have done a really good job, I have to say. Veterans come to us all the time with different stages of progress in their claims and appeals. Sometimes we work with veterans who have been fighting against the VA for years. They filed appeal after appeal after appeal, and they're still coming to us with the need for help. And I mention that because I think it proves that it is not as easy as thinking you have a meritorious claim, and if you just submit the evidence that you need, VA is going to grant it. This is a very, very complex process. In addition to thinking about evidence and development and legal arguments, there's also a number of procedural things that can come up in a case, just so many different types of things that can be tricky. So we recommend seeking help from a VA accredited representative or an attorney. These individuals can improve the chances of success. They can ensure that you have the correct and complete documentation for things. They can keep an eye on deadlines. They can definitely let you know when forms are updated. So that's something that we look at our office all the time to make sure that we're using the most updated version of a form. Because as we talked about before, that's really important. And also knowing when VA has totally gone off and done something contrary to the regulations. We have, veterans calling in wondering why such an obvious error is made. It can be hard to believe that VA is making an error because it seems like it's just so obvious that a decision shouldn't have contained a denial or shouldn't have done something that it did. This is a common experience in our world. And so if you're running into a situation like that, it's definitely good to remember that there is help out there for you and that you should embrace it and seek it because again, this it can just be a very tricky process to navigate. And so we highly recommend seeking help from VA accredited individuals and attorneys who have lots of experience with this process.
Yes. Don't go it alone.
Mhm.
And, in any situation where you're pursuing benefits, we just wanted to go over some common errors, some common maybe things that folks overlook
Mhm.
that can delay or interfere with their ability to get benefits as soon as possible.
Mhm.
But if you file on time, if you use the correct forms, if you gather the relevant evidence, you're off to a good start.
Mhm.
And just remember that it's always a good idea to contact an accredited law firm like CCK Law to help you navigate this system, which can
Mhm.
often be very frustrating. So, thank you for tuning in. Check out related videos on our YouTube channel and our blog. Don't forget to subscribe, and we'll see you next time.